Good afternoon. Good afternoon, everybody. On behalf of the ACC San Diego chapter and our sponsor, Signature Resolution, want to welcome you to today's webinar, 2023 Trends in Mediation. Leading our discussion today, I'd like to introduce Jonathan Andrews. He's a mediator with Signature Resolution. He became a mediator because he's passionate about the benefits of pre-adjudication conflict resolution and the importance of customized, empathetic, and people-focused mediation strategies to achieve a win-win outcome. He received his JD from University of Michigan School of Law's LLM in dispute resolution from Pepperdine. He has over 24 years of trial experience, 13 years leading his own successful law firm, and he's represented employers in all aspects of labor and employment law. We look forward to getting, Jonathan, your perspective on trends and best practices for successful mediation. So I'll turn it over to you.
All right. Well, thank you. I really appreciate that wonderful introduction. Welcome, everybody. I appreciate everyone carving out a little bit of time over the noon hour to connect on the topic of mediation. Certainly a topic that's near and dear to my heart. As was mentioned, before I became a mediator for 24 years, I was an employment litigator. And in that time frame, managed or worked exclusively with management on employment issues, from advice and counseling to litigation, in trial work to investigations. And I'd like to tell people, and I apologize in advance if you've heard me say this before, we mediated together, but at the time I started litigating, I had hair. I would laugh a lot, I smile a lot, and then with each successive trial, more hair fell out. I smiled less, it became more difficult, and eventually I decided really in about 2020, 2021 to go full-time into mediation and arbitration, where I focus exclusively on employment-related issues, single plaintiff cases, class cases, representative actions, employee mobility cases. And again, because as my entire adult life was spent entirely focused on employment litigation. So I wanted to use those skills in a different way. One was spent in trial and advocacy, and now really trying to bring people together. And it's been a wonderful experience so far. I mediate cases really throughout California and also throughout the country. So I do a lot of work in New York and Florida, Texas, and Illinois, in addition to California. So during this presentation, I'll encourage folks to either use the chat, or I don't know if we have a tremendously large group, so we might be able to, if people have questions, either to raise their hands or even come off mute if you'd like, and ask me questions. What we're going to be talking about here today is really going through what we're looking at as neutrals, and also through our conversations with folks like yourselves and other consumers and advocates. What are the trends that we're seeing in 2023, some of which we think transcend next year as well, but then also tying that into working effectively with your outside counsel and your mediator to try to really maximize the effectiveness of your mediation experience, because that's a lot of the questions that I get, is someone who for so many years was sitting in your chair in a mediation room, trying to work through and really understand what a mediator was trying to tell me, really trying to now share some of those perspectives. And I feel like I'm in a unique situation because I probably have worked with, if not you directly, a number of your colleagues in different companies. And when we start talking about some of the things outside counsel can do better, I'm probably going to be referring to some of the things I think I could have been doing better as well, in the mediation setting before I became a mediator. So those subjects will certainly invite questions if people are comfortable in asking them. So with that being said, let's start. And so the big question that people ask me, and in fact, I'm speaking to you right now from our mediation kind of headquarters in San Diego at Signature, and I was talking to a number of our neutrals earlier today about some of these trends that we're seeing. Many of these won't surprise you. Some of them may, but the trends that we've seen this year that we expect also to carry into next year. First, virtual versus in-person versus hybrid. Hybrid is when we have one party present, the other party attending virtually. I've heard some people say, John, at some point the in-person is going to return in mass. And I will tell you right now that does not look likely, at least not in the next 3 years and perhaps 3 to 5 years. Right now, we're looking at probably 85% of all mediation still appearing virtually. And we're looking at then another maybe 10% that have a hybrid component and then 5% in person. And the reason for that is that there has not been at least a visible difference in the success rate of mediations, whether they're virtual or in person. And so and that's been experienced by everybody, such that there hasn't been that impetus to say, you know what, we need to get in person in order to increase that effectiveness. And it's also become a lot more convenient for the parties. And that just can't be overlooked. So I hear it from counsel for both plaintiffs and defendants saying to me, it's just so much better to not have to fight traffic in. I do a lot of mediations in Los Angeles. Go to Century City, go to Los Angeles, go to downtown LA, and fight those 2 hours. It's much easier for me to get my client on board and be there on time, and also stay later if we're able to do it virtually. And on the defense side, it might be much easier to get key executives from other areas of the country or insurance carriers who might not otherwise participate in a mediation, or at least not participate in any format other than through the phone, but actually to weigh in on screen if we're doing it virtually. With that being said, there are certainly cases that I still hear that people say we should try to mediate in person. And there are cases that I see personally that benefit from in-person attendance if possible. Those are usually cases where there is some emotional component to it, and it can be on either side, that would benefit from more of a one-on-one discussion, perhaps with the mediator, and more time spent in that kind of personal connection space. And I see it also with the employer, particularly in PAGA cases, that have a very emotional component to it for especially small business owners, being able to spend more time connecting with them and helping explain to those parties what the process is like. And it can be, as you might imagine, a very traumatic experience, especially for a small business owner to face some type of class of representative action. And also for cases where papering the case, in other words, getting the settlement paperwork executed, reviewed and executed that same night, while that can be done through DocuSign and other formats virtually, being able to walk through those papers and get it done right then and there at the mediation really is a benefit. And so for those cases where those things are really important, getting the emotion kind of worked through, making sure that if we reach a resolution that we get it papered, those are cases that I see people try to see if they can get done in person. The other big trend, and this is kind of tied into some of these other bullet points, is the normalcy of mediation. It ties into to confidentiality and mandatory mediation and specialization, but the increase in the number of mediations that every agency is seeing is remarkable. And that is because mediation once was an outlier. In other words, everyone was accustomed to going through litigation. Mediation was viewed as somewhat of an off-ramp, an opportunity to kind of set litigation aside, go into a different mode, see if you can resolve the case. Mediation now has almost become a part of litigation. It is so common that we sometimes see a little gamification, if you will, of the process, where parties sometimes are coming into mediation now, and not necessarily with the sole intention of resolving. I think everyone wants to resolve at the end, but it's really almost a step in the litigation process. And I think because of that, we're seeing just more of trying to work through and see what the party's true intention is in trying to come to the table. And sometimes that is manifesting in spending more time at the outset, really kind of going through what the real key issues are in the case that are going to have to be worked through in order to get to a resolution. And it is really this, I would say, the kind of the cost of normalcy. And courts are certainly pushing it. As most of you know, state courts can't require or force necessarily parties to mediate, but they certainly can strongly suggest it. And when they do, parties try to take them up on it. But it's very rare that you're going to get to trial without a court at least ordering you to an MSC, or at least strongly pushing you into some type of settlement conference or private mediation. And which I think are all great things, and it's always good to explore those options before heading into trial. But the fact that it is just almost an expected part of the process, I think, has sometimes changed the approach that people bring into mediation. Again, where it could be this opportunity to get something resolved suddenly becomes more of a step in a process of getting to trial. The other big trend that has really been picking up steam, and it's been really in this last year, is the argument of non-economic damages. So emotional distress and the focus on that. Where in the past we used to see, particularly in employment cases, but you'll see it in personal injury, a real focus on the objective kind of hard number and data of economic loss, partially because it's hard to really refute. We're seeing now cases where, especially on the plaintiff side, they're saying, I'm not even going to argue economic damages. I don't really care about that. I don't need an expert. I'm not really worried about that. I'm going to focus my argument on emotional distress. And the reason for that is because if you've been watching the news, you've seen some tremendously high employment verdicts where most of the damages, if not all the damages, are attributed to either emotional distress or punitive damages. There's an example, the Diaz case that many of you may be aware of, about a year and a half ago up in Northern California, where a jury came back and awarded plaintiffs in that employment case $130 million. And I believe it was about $6.5 million or so was in emotional distress. The rest was punitives. That verdict was later reduced by a judge through a mediator to $15 million. The parties refused to accept that and retried the damages. And the retrial on the damages, that the emotional distress damage award was now reduced to $175,000 by the jury. And so before employers throw up their hands and say, hey, here's a big success, where I'm really seeing that case used is actually more on the plaintiff side by saying, it is so unpredictable where these numbers could lie that I'm justified in saying 100 or 50 or $5 million because the same one jury that might look at these sets of facts and say 175,000, another jury may look at this and say, you know what, you're going to get 100 million out of this. And so there are no bright line tests on emotional distress in terms of what amounts need to be awarded. And a lot of cases that come to mediation, the emotional distress component of the case hasn't been thoroughly worked up. It's usually prior to any type of independent medical examination that's taken place, or prior to expert discovery on those issues taking place in any source, in any form or fashion. So it becomes an easier vehicle for a party to throw numbers up against the wall and say, this is what I'm going to get. So it's something that we talk about when I talk to companies or talk to counsel in terms of how do you prepare a case, is really focusing, and we'll talk about this in a moment, focusing on anticipating that argument and what do you need to do to try to get yourself in the best position to address those arguments in mediation, whether it's through certain written discovery that needs to take place, research on cases that have been decided or in your venue by that same judge, whether that judge does remitters on various cases, to try to push back on a demand that's going to be frankly quite high and be based on numbers that you're not really going to be able to attack independently because they're so subjective. The other trend that we're seeing is a push for diversity in mediation. And what that means is it's not just simply a push in diversity in terms of persons of color and women, although that's a huge push. It's really the idea of cultural competency, meaning that there is a desire by parties to work with mediators, particularly employment cases, but it really runs the gamut. To have some experience, or at least an openness and a willingness and an ability to navigate different cultural issues that come up in the context of mediation. And so we refer to that again as cultural competency, but you'll see in this slide, and this presentation will be available to all of you after, both the ABA model standards and the California rules of court both have regulations or rules that at least contemplate competency with respect to diversity as being a core component that mediators should possess. But you're also seeing agencies like Signature, where I'm part of, or JAMS or Judicate West, all being concerned, ADR Services and other, with trying to open up to you, the consumer, more options on the mediation panel. It's traditionally been, as many of you know, former judges, there's just a certain demographic that was kind of really kind of graced the panels for all of these organizations. And I think people are realizing that there's a real benefit to having more options and choices of who to use, who to work with. And the model standards really go to that. And part of that also, when it was referenced in the earlier slide, goes to specialization as well. You're seeing in the context of mediation, agencies really looking for people that have subject matter expertise, in addition, certainly to former judges, again, to provide more options to you, the consumer. I, for example, I may not be the typical recruit when I started with them, in the sense that I wasn't a former judge or a public defender or OAG or anything like that, but private in private practice. But because 24 years was exclusively with employment law, there was an appeal there to try to tap into that experience as a mediator. We're seeing that also with family law as well, where that's a growing field where really specialization, people that were formerly on the bench or people that formerly practiced exclusively in those areas, are where agencies are looking for. And that's, again, a direct result because that's what you, the consumers, are looking for as well. So I'm excited by the fact that there is this openness and willingness to try to expand beyond the typical profile. And I would encourage you, when you're considering mediation or you're talking to outside counsel about who to use, realizing that there are more options than perhaps existed 5 years ago or so, and really looking to find someone that really works with what you need. I'll pause for a second just to see if there's any questions. Okay, so mediator perspectives. One of the things that I did is I spoke with our roster, and so with Signature, if you don't know, we have offices in San Diego, Los Angeles. 2 offices in Los Angeles, Century City and downtown, and then also in Oakland. And I think we're now around 65 or so neutrals. And so I reached out to everybody to talk about some of the things that they've been seeing as well and their perspectives. And one of the questions that was asked was really kind of, what are the 3 main issues that you're seeing outside counsel and defense counsel struggle with in mediation, at least from the mediator's perspective. And you can see from the bullet points that have turned into to more than 3. And so I'll focus on kind of the big 3. One of the biggest things that I see is coming into a mediation with a clear sense of the value of the case. And what I mean by that is really having all the information that you need from your outside counsel to really properly value the case. And then also getting from your outside counsel their perspective on how the plaintiffs may value the case. And that latter point is often difficult. And I know as defense counsel, it wasn't something we always focused on enough until, perhaps we're looking at closer to trial. But what I mean by focusing on the plaintiff's perspective is, it's not uncommon in a mediation when the numbers start to come in for defense counsel to say to me with their client, we don't understand where these numbers are. And I understand that because sometimes these numbers are hard for me to understand. But what we don't see is that looking at various character variables, the venue, the judge, the state of the case, any past verdicts that this particular plaintiff's lawyer may have had, none of these things maybe change the needle in terms of how you value the case. But understanding what those items are will help you have a better understanding of why the plaintiff's counsel is valuing the case the way they are. And really, it's not intended to persuade you to change your position, but it gives you more ammunition in being able to go into the mediation with a strategy that will be able to rebut some of the arguments that end up coming up in the course of mediation that can prove to be frustrating. And so it's part of all in that preparation. I'll see in cases where defense counsel may not have a clear idea of, if the case doesn't resolve, what is the cost to the client going to be of the case going forward. I had a case the other day where there was the threat of a summary judgment motion. And when I asked a little bit about that, defense counsel couldn't recall the judge that the actual motion would be heard in front of. And that's fine. I'm not trying to call someone out, but you start to lose some credibility, as you might imagine, in making an argument about the potential effectiveness of a motion when you don't even have a sense as to who's going to hear it. And so I would imagine from a client's perspective, that's all information you'd want to have as well. What happens if we don't settle this case today? What are those next steps? What are those costs going to be? What are our likelihood of success at that next phase of the case? And so where I see mediation struggle from in-house perspective and from the defense perspective is when there's not a clear handle on what those various variables are going to be. The other part of that, it's connected, is really exchanging information. You'll see here sharing information with the other side. In my experience, I would say probably it's a disproportionately high number of plaintiffs' counsel will share information pre-mediation with the other side than defense counsel. And I am always trying to encourage both sides to exchange information. There's absolutely no downside to doing so. And if you have, particularly if you have a case that you feel strongly about, and there are cases that you feel are somewhat on point that you think you want to share with me, it is often so effective to share that with the other side beforehand. And then I take that brief as a mediator, or any mediator would, and I can go through that, not just with opposing counsel, but with opposing counsel and their client in the room, and kind of go through bit by bit. There's an old trial adage that show, don't tell. And that's a truth with briefs as well. And the briefs don't need to be Shakespeare. They don't need to be so voluminous. It's really just putting your key points out there so that the other side, and particularly their client, can see that there's been some thought given to this. And here are some points that need to be considered. Trust me, they're not going to jump out of their chair and say, you know what, John, we read the brief and everything that's in there is right. They're not going to say that, but that's not really the point of it. The point is to try to educate them as to the risks in the case and give a roadmap that I can then use with them to help them understand those risks, so that when I leave the room, that's where the real conversation takes place. And they can talk with their client about what those real true risks are before they come back with another number. So sharing information. I don't know why defense counsel doesn't share information. And that's a weird thing for me to say as a 24-year defense counsel. So the only thing I can think of is that, and there's a couple of people who have said this, and they can remain anonymous, is a fear of being wrong. That they're going to provide a brief and plaintiff's counsel is going to pick it apart. And they're going to point out that there's a case that's better than the one, or better for plaintiff than the one that defense counsel put out there. I think the risk of that is low because everybody, I think, works hard to put out their best product. But also, isn't that information you want to know? I would often tell people when I was representing companies, tell me why I'm wrong. And I wouldn't say it in a confrontational way, but it only helps the client to know, are there some holes in our case? Is there other authority that could possibly change the value of the case? That's information you want to have because that's also part of the purpose of mediation. Certainly we want to resolve the case, but you want to have the information that you need to make the best decision that you can possibly make. So I would encourage, in coordinating with your outside counsel, sharing information, or encouraging them to prepare a brief that can be shared with the other side. You could also have a private brief that's shared with the mediator. And I see that often where that information may be information, let's say, that you think might be inflammatory. You don't want to share it with the other side because you think it's relevant, but you want to make sure that it's delivered by me in a way that's going to move the ball forward. And you think by throwing it out there ahead of time, it may just blow up the process right from the start. Absolutely understand that. Or you may have declarations, or at least you think you may be getting declarations from witnesses that you don't want to disclose to the other side yet, but you want to share with me because you think it may ultimately become relevant. So that certainly is something that's appropriate to do as well. So there's different ways to really tee things up. The last thing I'll say with this, in terms of mediator perspectives, things that we'd like to see and encourage more of, is communication with the mediator. And I'll start with pre-mediation communication. I always reach out to the parties to have a pre-mediation call. I would also encourage, especially as in-house counsel who's going to attend the mediation, to attend that pre-mediation call and get a sense of questions that I may have, things that you want me to be focused on. It can often kind of help us hit the ground running when the mediation starts. And there's no reason why you shouldn't or couldn't be a part of that, other than obviously being busy in your schedules. But as mediators, we often want to have that interaction with everyone that's going to be involved at the actual mediation beforehand, because it really gives us that opportunity to be available to you for questions that you may have about the process, questions that often get asked at the start of the mediation, but that could be dealt with beforehand. We touched on this a moment ago, but the goals of mediation. So we always want to resolve the case. That absolutely is the goal. But the process matters. And if you've mediated with me, you'll hear me say that often. Coercing parties into a mediation or into a resolution at mediation, to me, is not a successful mediation. And I don't think it's a necessary tactic that mediators need to use in order to get parties together. I've experienced it as an advocate. I've mediated with people that are very aggressive in how they try to position the parties. And even on those instances where it may lead to a resolution, the experience is so negative that it kind of changes whether or not you ever want to use that mediator again, but it also can impact your relationship with your client or your relationship with outside counsel. I think the process through which we approach trying to get the parties to resolution as a neutral really does matter. And so as part of that, going into a mediation, in addition to wanting to resolve the case, getting information from the other side is critical. And so using the mediator to try to get that information, I think, is something that we all encourage people to do. And so you'll always hear me say, if there's no such thing as a bad question. And if there's any questions you want me to ask the other side, any information that you think is important for you to understand, even if it may not be, clearly relevant to the case, that's okay. Ask me so that we can try to get that information over to you, so that to the extent it has an impact on your analysis, you can then have that in your back pocket. And then at the end of the day, when you make your decision as to whether or not you think that we're able to get a deal done, there's no questions about, well, I might be able to, but I just need more, or any questions like that. The other part of mediation, and this goes to what I said earlier about how the normalization of mediation is the concept of messaging. Mediation can also be an effective way of communicating a certain message that you have about the company, about the case, about your counsel. But through the mediator can be a really effective tool at setting out the theme of your case going forward. You want to resolve the case, but at a minimum, you also want the other side to really understand kind of what your overall intentions and confidence level is with respect to taking the case farther. And then also framing the disputes. And what I mean by that is, in a mediation, even if the case doesn't resolve, perhaps what the parties can do and what you can do is have a clearer idea, at least help the other side have a clearer idea of what are the real key issues in the case that are going to drive resolution or drive the success or non-success of a trial. So I think through a really well-crafted strategy, you can begin through the mediator to frame for the other side what the true issues are in the case, and perhaps also frame where the valuation comes from. Meaning, I had a mediation yesterday where defense counsel said quite effectively, we're not really worried about the liquidated damages component of the particular case, or the willful component and the attached penalties. We're negotiating off the number of, in this case, really the hard economic overtime damages. And it's not that the other side necessarily agreed, but the message was so consistent, the framing was so consistent throughout the course of the mediation, that at the end of the day, the negotiated numbers really were focusing solely on one category of damages and not the other, which has an impact on the end result. And that was a strategic decision by counsel, defense counsel, and their client to frame the issue, give me the information necessary to help frame the issue for the other side. And so even had the case not resolved, and it did, going forward, that still would have been now the new framework that the parties were operating under, and would have allowed, I think, for a settlement to occur, probably the next week if it hadn't occurred yesterday. One question that people ask me all the time, and is there a right time to mediate? And this is, a hot topic. My answer on this, and it differs, I think, from a lot of my colleagues, is there's never a wrong time. I'll say that to mediate a case. The decision to mediate and when you do it, I think, can have an impact on, one, it can have the valuation of the case. Where you are, whether it's you have a pending motion for summary adjudication or judgment, that pre-dispositive motion MSJ creates interesting challenges. It's a zero-sum argument, and you think you're gonna win on summary judgment, perhaps, or you're not. Whether you're doing it right before trial, and if there's attorney's fees involved, that's going to roll into any potential valuation of the case. The one thing I would say, and it should be obvious, is that if there is key information that dramatically you think could alter the valuation of the case one way or the other, and that information hasn't been obtained yet. Let's say there's a key deposition that hasn't taken place. The question is, do you mediate that case prior to that deposition taking place, or wait? And again, I don't think there's a bad answer to that, frankly. The only thing I would say is that if you think that that piece of information, written discovery or deposition, is absolutely essential for you to have at least a proper understanding of the value of the case such that you can mediate, then certainly you should wait. But I could imagine a case where having that key piece of information hanging out there post-mediation could also drive the parties to resolve the case, where they both sides know that the way a deposition may go could either gut the valuation or increase it dramatically. And sometimes that unknown can be a catalyst for resolution. But I think really looking at, and I think working with your outside counsel on how do you value the case? And I can imagine some of you might laugh at this or smile at this. You've seen this before. When you get a pre-mediation evaluation or initial evaluation from your outside counsel, and they say, we will be in a better position to evaluate the value of this case after we take plaintiff's deposition. And so they leave the number blank. It's a true statement, but it's not very helpful. And if that's truly the best that defense counsel can provide to you in terms of evaluation of the case, then perhaps that deposition really does need to be taken so that they can give you more guidance. But odds are that you can get a sense of that value anyway without that deposition taking place. So really where that stage of the case is, mediating anywhere in there is terrific. And you're going to get more bang for your buck sometimes pre-litigation. You may pay more than you initially may think you want to, but it's a lot less than you might ultimately do later down the line, just simply because attorney's fees aren't rolling into the case and emotions haven't been revved up. There hasn't been an expenditure of internal resources. And certainly pre-trial, there may be a higher valuation, again, just based on the work that's been done, but you may get more value out of it because you don't want to be in trial. And now that you know that that's the only other option, it just makes the decision a lot easier. So I hope that makes sense. But these are all things that we see that can really impact the success rate of a mediation, with people really understanding why they're there. And then choosing the right mediator. We talked about this earlier. I think, and this is my opinion, and I'm sure I was guilty of this, as defense counsel, sometimes when we're contemplating a mediator selection, defense counsel will simply send out an email to either people in their office or perhaps the firm, but it might just be within an office, and says, has anyone heard of so-and-so? And there'll be some comments, they're pretty good, or I wouldn't use them. And that's about it. They're generally very vanilla. And based on that information, someone's going to say, all right, I'm either going to use this person or not use this person. And my point is, I don't think parties on both sides do enough diligence in contemplating who they want to use for a particular mediation. If someone says, I don't like someone, it's usually because the case didn't settle, or they didn't feel the mediator agreed with their position. Mediator may have been fantastic, and that person may have just been a difficult person to mediate with. They may never settle cases because of the way they posture the case. But I think you want to coordinate with outside counsel on making sure that there's a little more depth to their recommendation as to why they want to use someone or perhaps not use someone. So, a question that often comes up is, do we want to use a judge? And so part of that discussion may be, do we want to use a judge who's recently come off the bench and is now just kind of getting up to speed, maybe terrific and may ultimately be a great mediator, but perhaps because they are just coming off the bench, they're still in a judge mode of, I'm going to tell you what to do, as opposed to listening and trying to facilitate resolution. And that's a generalization. There's obviously judges everyone is capable of doing great things right off of the bench as well, obviously. Or do you want someone who is a practitioner, and or who was, and for how long, and are they a subject matter expert in your opinion? Were they on the plaintiff side or defense side, and does that matter? And where do they actually practice? Is this a case venue in San Diego, and they they spent most of their time in Los Angeles. Again, none of these are things that necessarily knock someone out or bring someone in, but it can paint a better picture for you in terms of deciding, is this someone, especially with the cost of mediation being so high now, where in Los Angeles, I don't know if you mediate many cases for under $10,000 in a day. It's become so expensive. You really want to give some thought as to who you're using in these cases. The agencies themselves, I think all the agencies are great. And I know I'm with Signature, so I have to say that we're the best. But frankly, a lot of the mediators that I really loved using were also at Judicate West. There's great people at JAMS. There's great people at West Coast. The agencies themselves, I think, I don't know how much that moves the needle in terms of selecting someone, other than perhaps they have a pool of people that you really like using, such that if someone's not available because their schedule's so busy, you know that there's going to be some other people that they can recommend and get you connected with. With fees, as I mentioned, mediator fees are skyrocketing. And a big part of that is because people are recognizing the value in being able to find someone and work with someone that's going to settle the case. If the case doesn't resolve and you're going to spend another 150 to 250 or more in fees to potentially be in the same situation a year from now, mediating the case now at a different value, that finding someone that really can be effective and useful and helpful and get the deal done and get it done in a manner that's going to, I think, be respectful to yourself, to your counsel. There is real value there, and I think people are recognizing that. And with the number of cases that are out there now, a lot of good mediators there, it's difficult to get scheduled in the next 3 months, especially as we're getting close to year end. This is when things really start to get busy, as both plaintiff and defense side want to get cases done before year end for a variety of reasons, tax reasons, among others. So paying attention to those fees, I think, is important, and it really ties in again to, well, why are we paying someone this amount of money, to sit down with us? Are they someone who is going to follow up? I know for me in selecting a mediator, overall, I wanted someone who was going to work hard. I wanted someone who was going to do pre-mediation calls, and those are the questions I would ask my colleagues. Do they do pre-mediation calls? Do they follow up if the case doesn't settle? Do they do unsolicited mediators proposals? Because that's something that I was never going to be on board with. How do they interact with the clients? Are they open to ideas? In other words, are they collaborative? These were things that were important to me and were often important to the clients that I was working with. And so those were the things that I was looking for in selecting a mediator. Sometimes those were judges, sometimes those were practitioners, and they could have been at various agencies, but was really trying to drill deeper into, is this the person that's going to work well and communicate well with my client? And is this someone also that's going to communicate well with the other side? Because if they're not going to communicate well there, it's not going to result in a successful mediation. I'll go through this quickly because we touched on this earlier. This and I expressed this as a trend, if you will, or at least a perspective that other mediators have shared with me and that I've experienced as well, in terms of things that that they think could be done better in terms of preparing for mediation. But the pre-mediation assessment, I've seen it. I've seen it too many times where that assessment is really boilerplate. It doesn't have the parties aren't coming in with that clear understanding of potential liability or damages, maybe not even being clear what the relevant standard is in terms of determining fault, or understanding what damages are available, and not realizing that there could be treble damages on particular claims. Having a clear sense of that beforehand, I think, is so important, because that's going to impact what authority you're coming in with. If you, as in-house counsel, are working with different various internal client groups, making sure they have the relevant information so that they're not surprised if they get a call at 4 p.m. at the mediation asking for more authority. The other issue for those of you that have insurance is allocation and coverage issues. These are issues that should be dealt with well before mediation, so that they don't come up where you're getting close to a settlement and suddenly a carrier says to you, you know what, you have to pay 75% of this, or we're only going to cover 25% of that. That's something obviously that you want to have worked out beforehand. We talked about this earlier, the budgeting, what happens if the case doesn't resolve, and having a clear understanding what that cost may be. Sometimes I'll have defense counsel tell me, you know what, we're going to take this case. If they don't accept this number, we're taking this case to trial. We're going to depose the next 40 people on this list. We're going to do this, we're going to do that. And I'll see the client's head slowly turn over to their counsel and say, let's take a break for a second. And then when we come back, it's the client talking. And the reason is because there's a disconnect there sometimes with defense counsel and the client about what happens next. Taking 40 depositions on a case that might be able to settle a delta of $5, $10, or $10,000 doesn't make a lot of sense. Doesn't necessarily serve the client's interest unless the client is clearly on board. And if there's not a clear understanding of the cost of not settling, then it's really hard to really have a proper evaluation of what the cost of settling is. The other question that comes up frequently, and especially this year, and is whether or not there's value in soliciting a pre-mediation demand. And you would think this wouldn't be so controversial, but it actually is among the defense counsel that I work with. There are a number of defense counsel that say, look, I will not agree to mediation unless I have a pre-mediation demand. I need to be able to inform my client as to what the expectations may be, at least in the plaintiff's room. And in my experience, pre-mediation demands, I think, are absolutely appropriate to ask about and ask for. How valuable they are really depends on the relationship with counsel. If you have a good relationship, or your outside counsel has a good relationship with the other side, then there's going to be some transparency in terms of what the expectations are going into the mediation. But like in most cases, it's still adversarial. And so what I see happening with pre-mediation demands is it gives the other side an opportunity to throw out a very inflated number. And so when they get to mediation, they just look at the defense side and say, okay, you start. Rather than if going into a mediation, if they try to do an inflated number, they have to do it through me or through through whoever else you're using. And that provides, the mediator an opportunity to do a little gut check with them before that number is communicated. So I'll just a thought that what you're seeing, I think, from the other side is almost encouraging that request to be made because it provides an excuse to throw out a really high number, and then make you as defense counsel or as the company be the one that has to move first when you get to mediation. So there's nothing wrong with making the request, but the information you're getting in response may not be that useful or helpful. So I wouldn't use the lack of a demand necessarily to preclude going to mediation, because ultimately, as a company, you have the checkbook. You're going to decide what you're willing or not willing to pay. And so you can decide going in whether the other side says it's a $10 million case or $10,000 case. At the end of the day, it's going to be how you ultimately look at the case and value it. So I wouldn't let that preclude you from going forward, because the accuracy of that demand is often, I've heard people say it, they really just throw numbers out there just to see what will happen. And I'll pause again. And I apologize if there are questions that I've been asked that I haven't had a chance to take a look at. If not, that's fine as well.
Yeah, there's no questions in the chat, but definitely add questions in the chat, or feel free to come off of mute or raise your hand, and we'll keep an eye on that. Jonathan, I think on that last point, I thought it was really interesting because, knowing whether to have the number up front or be surprised at mediation, with maybe a very high non-economic demand, right? I think that's a real struggle, because I think, from the defense side, coming in, not knowing what that is, getting surprised, and then trying to sort of pivot and shift in terms of that conversation that needs to happen at mediation. How do you address that, as a mediator, when a plaintiff comes in, maybe hasn't issued the demand beforehand, comes in with a really high non-economic demand? How do you deal with that as a mediator and sort of set that tone early on to try and get to a successful resolution at the end?
One of the things I do is in pre-mediation calls, I always explore with both sides what settlement discussions, if any, have taken place. and also try to get a sense as to, where they think the other side is coming in at, perhaps at the start, which can also, which for me as a mediator can kind of help give me some foreshadowing that I can perhaps share with the other side going in. And where you might hear in my initial meeting with you talking about how, the first number you may hear maybe a lot higher than you ever thought about, but trust the process. We're going to be able to work through it. And that may be that I have a lot of work to do in the other room. I may be getting that sense of it and be able to give you that indicator. It doesn't necessarily take away that frustration, though, of saying, well, what are we doing? I mean, and if you think this case is worth so much money, take it to trial if that's what you really think. But we're here to try to resolve it. I would say it's become, you'll get a sense if that number sounds so disproportionate to how you value the case and working with counsel, how they value the case, then you feel pretty confident that this is, all right, we may be here a little bit longer, but it doesn't change your analysis necessarily, unless there's been some new facts. It just means that credibility wise, the other room has lost some. And this is something often the mediator will say, you go with these numbers, there is a credibility gap. And sometimes I will say, sometimes you'll see the other side start at certain numbers that are high because they feel like they have to give a certain effort, if you will, to their client to say, hey, I asked for it. You wanted me to ask for it. I'm asking for it. They're not going to give it. And then you start to work on down. So I try to give at least counsel, let's say for the employer, that heads up beforehand if I get the sense that that's where it might be starting, so that they can share with the client and prepare. But we still often see the surprises. It's just that when you have a pretty good analysis of where the case is, the surprise, instead of being so frustrating, almost becomes a little more comical, if you will. And you say, it just makes no sense. And it impacts your strategy, how you're going to respond. I always tell people, one of the most effective things you can do is put pressure on the other side. And you do that by making actually reasonable offers on both sides. That's what puts the pressure. That's what allows the mediator to put pressure on the other room. And frankly, it causes some tension in the other room if the employer, and I'll just use an employment case as an example, is making reasonable offers and the other side is staying unreasonably high. And suddenly you on the employer side just slow down. This doesn't make any sense to keep going. It creates tension in the other room. And you suddenly see, the plaintiff and their counsel saying, why did this slow down? What's going on here? Maybe we should be doing something different. And it's because that pressure that's being put on. When both sides just start and stay at these high ends, no one's really feeling that kind of pressure. They're frustrated, but they're not feeling that pressure. So, it goes to trying to ignore sometimes what those high numbers are, and sticking with your strategy, at least at the outset, to see if that starts to move things that way. Quickly with selecting the right attendees, I point this out because I think sometimes it doesn't get enough attention. Who's actually going to attend the mediation? Clearly, you want to have and need to have someone there with the authority to settle the case. It's one of the first questions the other room is going to ask. Who's there? They have a right to know who's there. I know I've had some mediators when I was practicing that wouldn't tell who was there. I didn't think that was appropriate. I think that as someone who's at the mediation, you have a right to know and should know who's in the other room, the other virtual room. And so you want to have someone there that's going to have the ability to get the case settled. I understand sometimes, depending on the numbers, phone calls have to be made as well. That's inevitable. But at least you want to be able to have someone there so the process doesn't get bogged down. Sometimes, depending on the case, also having someone there that can speak to the facts of the case. That doesn't necessarily mean it has to be someone from the company, but I often will see at a mediation, you may have the partner on the file who attends, but the partner hasn't participated in any of the fact finding. And that's okay. But if the case really is going to be one where we have to go through some of the facts, sometimes then having perhaps that senior associate or associate also there who can go through those facts better can be more effective. Or having someone there from the organization that knows of the facts or knows of the policies and procedures that are in place can help push back more quickly on some of the allegations in the other room. And then declarations can be really effective. depending on whether or not they've actually been signed and whether or not there's a willingness to either share them with the other side or at least share them with the mediator so that the mediator can represent to the other side that he or she has seen them. That can be persuasive, especially in a harassment case or a case where the corroboration or lack thereof is an essential component of the valuation. Lastly, experts, depending on the phase of the mediation. I've used experts as an advocate to talk about damages and breach of contract cases where I thought it was going to be really important to demonstrate to the other side that we had retained someone, we were willing to spend the money to have someone be there because we felt this was such an important issue and we felt that we were so correct in our evaluation. Really, again, depends on the type of case and the type of money that is being spent on it. But experts can really be, especially in an emotional distress case, can be really effective, especially if they've already been equipped with the information necessary to opine to the mediator under the mediation privilege. Their takeaways and thoughts on particular aspects of the case. So quickly, we've hit this, the strategy and process of it. Sticking with the plan, as I mentioned, is always important. I used to always tell people, tell mediators, the only thing that changes my valuation of the case is if there's new facts or new law. And a little bit of that is puffery, but you also want to be able to kind of stick to the plan that you've outlined and deviate if circumstances warranted. But you don't want to be influenced by some of these power moves that I identify here. The threatened walk away. If they don't come up to $100,000, we're out of here. Those are moves designed to bring you out of your comfort zone and to get you away from sticking to the plan. It's a tactic, even if the person saying it doesn't realize that consciously. It's a reflection more of that party's fear of losing control of the process than it is of something that you and your room are doing incorrectly or not valuing the case properly. The idea of integrated bargaining is really connected to, it's one of the last slides I'll show, is with looking at what some of these other options are that might move the needle in the other room, whether it's outplacement, whether it's a rehire, which can make sense in some disability cases where there's no performance issues and there's just simply a concern about whether or not something may or may not have been able to be accommodated a while ago, or someone had to be let go because they were out for so many months or years. But that can be something that can be part of this, what we call integrated bargaining, interest-based negotiating, agreeing not to fight unemployment, agreeing to extend COBRA if the plan allows for it, accelerated vesting if the plan allows for it, and that can have some value. In education cases, academic cases, what the title of the person might be, emeritus or something like that, if there's a separation. Those are all things that, even if not accepted by the other side, the mere willingness to consider those and express that willingness to the other side can really move the needle. And so that's something that you always want to try to explore with a mediator as well. And it goes to that last box of partnering with the mediator. Use the mediator, communicate with the mediator. We want to get the case settled. We give off a lot of cues. And it's not uncommon for someone to ask me, hey, John, what type of response would you give right now? Where would you go? And I may not have that number for you, or I may, but the information that I'm going to share with you is information that I think will be useful in overall getting this settled. You may not decide to go that route, which is entirely fine, but definitely use the mediator to try to get their gauge on what's the temperature in the other room. Who's really kind of driving things over there? Is it really driven by the party, or is it driven by the attorney? Does it make sense to bring the attorneys together to talk about this key issue? I'm one of those few mediators that really likes to do a joint session at the appropriate time, where there may be a time where it's important for the employee to give an impact statement. And that can be uncomfortable. But it can be highly effective at getting the parties together and resolving the case, and not by necessarily increasing the number. Often has the opposite effect, but that's just simply a really important component that has non-economic value to a party and something they need to go through. So all of these things are things that can be available in cooperating and working through the mediator. quickly on ethical negotiating, we hear this, there are rules that dictate, how parties are to negotiate. I have not seen a case recently come out that has tested these waters, although there has been some recent legislation attempted to be passed in response to the Girardi settlements and the famous Los Angeles attorney who's now in jail, dealing with what is actually occurring behind the scenes in the mediation. And so there are these rules of professional conduct about making false statements of material fact to a third person. Now, the mediation privilege itself, as it currently stands, is still intact, but there is legislation at play to erode that. Essentially, that if a party complains that some ethical rules are not being followed, that those communications can now be divulged to the state bar. And there's been a lot of pushback on that, and it's not yet enacted into law. But this idea of what is crossing the line is still very much in play. If someone says to me, there's no way that this case settles for $100,000, and they're willing to settle it for $200,000, is that an ethical breach? No, I don't believe it is. But what about saying, there is no insurance in this case, and I want you to represent that to the other side, and then they later find out there is insurance in the case? Is that a misrepresentation of material fact? I think arguably it is. And whether or not the mediation privilege can be pierced by that, there's a big push right now to allow for that to occur. So it's something to think about in kind of the zealous advocacy that you sometimes experience with counsel in terms of what parties represent and how far is too far. We talked about this earlier, the power moves. These are all things I'm sure you've all experienced, the walkaways, the best and final. I'm going to make a policy demand now for the first time in a mediation. These are all, again, designed to try to create client control issues, to try to knock you off of your plan. If there has to be a need to pause because something has really changed, then a good mediator will say, let's pause. They won't try to force the process through. And we talked about this with incorporating the mediator. Asking for advice, I think, is my big takeaway on that. A good mediator will give you that advice, and they'll give it to you in a way that's collaborative and seek your input as well. And with expanding the resources, these are all things that I think are on the table, whether it's outplacement, depending again on the size of the case and the size of the organization, and even apology. You'll see that there towards the end, and I've written about this, that in the guise of a mediation privilege, sometimes an apology can be really effective. It's not necessarily apologizing and admitting liability. That's not what I'm referring to, but it could be apologizing that there's been an impact a separation has had on a particular person, or that the process itself may have felt impersonal in terms of a termination. That can change things dramatically. And then my last thing quickly is mediators' proposals. There is this gamification. It's a trend that I'm seeing that makes us a little reluctant, mediators, to do these now, that we're seeing more people negotiate, both sides, on plaintiff side and defense side, negotiate off of proposals, something that really should not happen. In other words, parties say, you know what, I'm not really going to accept that proposal, I don't think, but let's just see if the mediator will put something out there that would just either raises the floor or lowers the ceiling. And so I would encourage you, before going through a mediator's proposal, to really explore what those critical terms are going to be, what happens if it's rejected, what the messaging the mediator is going to communicate with it, so that everyone's on the same page and you don't feel burned if you accept that proposal and it's rejected by the other side. Now that side says, okay, I'll do something close to that, because that can be a really frustrating feeling. And then finally, with the settlement paperwork, I always encourage counsel to bring settlement agreements with them, or at least have them available electronically. And then those are often things we can get done, whether in person or virtually, the same day of. And I've seen some really, crazy situations happen where I've actually had a plaintiff unfortunately pass away in between the time the case settled and in between the time the paperwork was signed. You do see some interesting things happen. People do change their minds. So having a settlement agreement together that has a lot of these issues here that are on the PowerPoint, outlined and addressed in a way that won't be require a lot of rewriting and discussion with the other side is I think really important. All right, I think might be right at 1 o'clock or just after, so
Yeah.
so thank you for your patience and with me in going through this. And I'm looking forward to the opportunity where we can be doing all of these in person again sometime soon. But I appreciate you taking your lunch hour to spend with me.
Thank you so much, Jonathan. This was really great. The presentation will be on the website, and I'm sure if you have any follow-up questions, you can reach out to Jonathan directly, but certainly learned a lot and appreciate your perspective on these, all of these items that you covered. So thank you.
All right, thank you. Take care, everyone.